Don't go there.
You are a technocrat. I mean, you can speak to whether or not it was appropriate or inappropriate for that to occur. Would you have done that as a permanent secretary?
Politicians get the information from wherever source that they can.
That's going to be the extent of your answer.
Yeah.
Don't go there.
There's a lot of noise around the data protection bill that, in my respectful view, is not warranted.
I was one of those making noise, and it's simply because I was concerned about that specific section 33.
Don't go there.
Are you going to be offering yourself up as political leader of the party?
I see you've called me here for much more than diplomatic passports. I don't mind that.
Don't go there.
What is the relationship like between you and your leader, Dr. Mitchell, your boss, Dr. Mitchell?
I'm not sure how to explain how to answer this question at this time. I prefer not to answer.
Don't go there.
They said that you approached the bank for the loan before the election and that it only materialized after the election. There are also conflicting reports around the quantity of monies that were received. What is the reality here?
People try to extort the truth and to make all kinds of things about it. I just stay quiet. So if you notice, I was really and truly quiet about the whole matter.
Well, except with not with the New Today newspaper. The New Today newspaper reported on this, so I'm not too sure you were quiet on this. Go ahead, Honorable. Go ahead.
Well, I'm just trying to answer your question, right?
Don't go there.
I think we just spoke at length about the regularization framework. So
yes, we did. But let us talk, Prime Minister. Let us talk about the workers who are dismissed.
The Bubb Report. We go there.
We seek the truth.
Would you be handing your resignation to the Minister of Culture tomorrow, sir?
No, I will not.
The leader of the opposition, you have accused your government, sir, of using the Grenada Development Bank to facilitate the financing of personal loans for certain government ministers.
The other side is in no position to talk about those issues, and I will leave it there.
We discover new perspectives.
You know his leadership style, and so many are saying, why are you coming now to talk about those issues?
Now is the time to speak. You have the right to decide who will take over.
And you met with Dr. Mitchell, and perhaps you might want to confirm what that meeting was about in your response. But
Dr. Mitchell, like myself, are Grenadians.
We ask the right questions.
Why was there no report on the work done of the commission? And how is this new committee different from the commission that was initially established back in 2022? So who are these elements that are using you?
I'm disappointed in my political leader.
And why is that animating those political conversations now?
This is a very interesting question.
The Bubb Report with Dr. Kellon Bubb. Thought-provoking, truthful, unbiased, and truly original reporting.
Last week, the government of Grenada presented before Parliament for its first reading the Age of Civil Legal Responsibility Act, Chapter 4A, or the Principal Act, to vest full legal capacity in minors aged 16 years or older to consent to any sexual or reproductive health treatment, including diagnostic procedures, without the need for the consent of the minor's parents or guardians, and to provide for related matters. The proposed amendment also allows the Legal Affairs Minister to grant access to certain services for minors aged 12 to 15 under special circumstances within clearly defined rules. Now, this specific subsection of the proposed legislation has animated a divisive debate in the national community in Grenada, with some who have inquired about the protection from legal risks that teens may face when making such critical health decisions as minors. Others have asked about the ability of teens to make such complex medical decisions without another adult present in the room. Of course, outside of a legal guardian or a parent. Then there is the question of who will be responsible for teens in the context of such decisions. On the other hand, policymakers in favor of this amendment have argued that this bill is about access and protection, which ensures that minors who are already in need of care can access it safely. Secondly, they have posited that it supports better health outcomes by ensuring that young people can receive timely, confidential, and appropriate care when required. Now, to give broader context to this conversation, it must be noted that in the strategic plan for Grenadian healthcare, published by former Minister of Health Nicholas Steele in tandem with the Ministry of Health in 2016, it said the following, quote, "The government has developed a national adolescent health policy and a strategic plan for Grenada as part of a focused approach in dealing with the problems confronting this age group," unquote. The plan then went on to identify the following challenges that teens face. One, that policymakers do not see adolescent health as a priority. Two, that outdated policies and laws relating to adolescents currently exist. Three, lack of input from adolescents on policy development or planning of services for adolescents. Then it goes on to talk about inadequate collaboration on the provision of services among ministries and NGOs in order to optimize the use of limited resources. And finally, a lack of awareness of available services as well as limited information on the health of adolescents. Of course, and then of course there is the Gillick competence, which treats specifically to the issue of the 12-year-old matter here. And of course, that question of the 16 and under issue around 12-year-olds has animated significant discourse in the national community. Now, this particular Gillick competence, I hope I'm pronouncing this correctly, it speaks to the right of a child under 16 to consent to medical examination and treatment, including immunization. And that was decided by the House of Lords in Gillick versus West Norfolk and Wisbeck in 1986, where a mother of girls under 16 objected to the Department of Health's advice that allowed doctors to give contraceptive advice and treatment to children without parental consent. Now, their lordships held that a child under 16 had the legal competence to consent to medical examination and treatment if they had sufficient maturity and intelligence to understand the nature and complications of that treatment. Now, since Grenada is still under the jurisprudence of British case law, this legal precedent may apply to Grenada's jurisdiction as well.
Should your loved ones pass on, they deserve to be treated with dignity. And at S.A. Johnson Funeral Home, we can provide you with that service. We can take you every step of the way during your sorrowful moments. When that need arises, call S.A. Johnson Funeral Home at 347-777-9797. That's 347-777-9797. S.A. Johnson Funeral Home is a Caribbean family-owned funeral home here in Brooklyn, providing funeral services, but in a dignified way. From cremation to burial to the repatriation of your loved ones, you don't have to go through the hassle, as we provide exceptional service that allows you to mourn and heal peacefully. For more information, visit our website, www.sajohnsonfuneral.org. Send us an email at sajfuneral@aol.com or call 347-777-9797. S.A. Johnson Funeral Home, because you deserve to be treated with dignity.
Now, here to make sense of this legislation are member of the grouping of civil society organization, Cassandra Mitchell, gender specialist, Mrs. Elaine Henry McQueen, and Dr. Tonya Frame, public health expert. Now, as a programming note, we did invite the newly elected chairman of the Conference of Churches Grenada, to the panel. That's Archdeacon Michael Marshall and a member of the Grenada Bar Association. Both parties reserved comment for a subsequent program. Now, ladies, welcome to this week's edition of the Bubb Report, and we're happy that you can join us for this very timely and, dare I say, very relevant conversation.
Good evening and thank you.
Good morning. Good morning. Thank you.
Yes, absolutely. So let us get into the conversation right away, ladies. Now, let us first and foremost talk about, because I think context matters. And in my intro, you heard me talking a lot about context. I know my intro was long, but I felt as if my the intro that I attempted to present sort of probably gave some context. Certainly, I'm not an expert. I only did this research for the program, but you are the experts here, and that's why I assembled you. Now, let us talk about the current deficiencies that exist in Grenada in the context of adolescent health and some of the challenges that teens face in accessing said care. Of course, I outlined some of those, but I'm sure that there are other cultural and socioeconomic issues that you can address. And Dr. Frame, I want to begin with you.
Thank you, Dr. Bubb. So a very important question to start. There are a number of challenges that adolescents face. These challenges have been known to those of us who work in this field for many years now. I have been working in this area in Grenada since about 2013 or thereabouts, or a bit before. And when I entered this realm, people like Mrs. Henry McQueen was working in this long before that. And so some of the barriers that we see, because young people, adolescents, are not having these conversations with their parents or vice versa, parents are not aware aware, right, that adolescents need these services. I think I can say that with confidence, that parents are not aware that adolescents need these services. I think there's a level of, my innocent adolescent, my innocent child, they wouldn't do this, right? And so there's no reason why they would need these services, because they do what they are told and what is expected of them. And so we don't have these conversations within our families. Our education system doesn't have these open conversations with adolescents as well. A lot of the conversations are around the biology and the reproductive system, around abstinence. So young people don't have a lot of access to good, accurate information from trustworthy sources and so on. So when they do need these services and they go to the health facility, some of them do attempt genuinely to access these services without parental consent. And healthcare providers, in a lot of cases, will turn them away. Not in all cases, but in some cases. In most cases, they get turned away because they don't have parental consent. They're asked to get the parental consent or bring a guardian, whether it's written or someone comes, and they don't return, right? Some of them may return with some distant relative or someone that may be trustworthy, that they find who is willing to come with them, or maybe a random person that is willing to bring them, right? But largely, one of the big barriers is that healthcare providers are unwilling to provide services for adolescents if they don't have the consent from the parents, because the law currently is gray as far as they're concerned. The challenges that they face, one, they say the age of consent for sexual activity, where adolescents won't get into trouble with the law, or someone who has sex with them won't get into trouble with the law, is 16. And so some of them say, well, if adolescents can have sex at 16 legally, then I don't see why I can't provide them with the means to protect themselves if they're sexually active, right? Okay. Others say, well, the age of majority is 18. So There is no way I'm allowing an adolescent who is not yet age 18 to access these services without their parents' consent. So those are some of the issues. I think some other ways that we can look at this. We think about these services or the issue of access to healthcare services for adolescents as a matter that is purely related to sexual and reproductive health. That is not the case. Let's look at this issue as a broad, holistic issue for the health and well-being of adolescents, right? Adolescents who need mental health services need access to health services without parental consent, because psychologists and counselors and so on will tell you that because we as a society, we don't buy into the whole mental illness concept, parents are not bringing their children to access these much needed services. And we see what the rates of suicide is like, right? Basic things just to maintain health and well-being. When we talk about sexual and reproductive health, we even include things such as menstruation. Simple questions around how to deal with these developmental changes are things that adolescents need to talk about. And so having access to healthcare services provides them with the opportunity to get correct factual information, get support, get services as well. The danger here, though, is that when adolescents do not have access to these services, we see what we are experiencing in Grenada and in some other Caribbean countries. We see high rates of teenage pregnancy. We see high rates of sexually transmitted infections among our adolescents. We also see, and some of that is happening because there is high rates of unprotected sex or unsafe sex. And adolescents may think that they are practicing safe sex by using methods that are not safe, or they're using methods such as condoms, which are said to be safe, but they're using it incorrectly, right? Some of them may be using contraceptive methods such as the pills, but adolescents, based on where they are developmentally, that requires a lot of being planned and organized and so on. So if there's a space that's created, if the law creates the space for adolescents to access these services, we are in fact protecting our young people. And I appreciate the conversations around this. I think this is a wonderful opportunity for us to dissect this matter, because we've not had this very open public discourse. Up to this point, these matters have been open secrets, I like to call them. We all know it's happening. We all know what the problems are, but nobody's talking about it, right? Yeah. And then we say we are a Christian society, so we cannot do this, right?
Right.
But we know.
That right? Is absolutely.
But we know that some of these things are happening. How much we understand it is in question. And I think this is an ideal opportunity for persons like myself and others to now start to have these conversations with the population about the extent of these challenges and why what the government is proposing is not novel. The government is not proposing the most extreme, that we've seen in terms of these kinds of laws. But the intent of the law, from where I sit as somebody who works in sexual and reproductive health and rights, and who works in public health as the broader field, this is a mechanism that is much needed to give not just adolescents this space, but healthcare providers, right? And our society, the space to protect and to care for our adolescents in a way that we have not done in the past.
Let me bring in Ms. McQueen. And Ms. McQueen, in your opening salvo, I want you to pick up, and of course, Cassandra will be coming in right after. But I do want you to pick up, Ms. McQueen, on the whole issue of the current setup around sex education in schools in Grenada, and the extent to which those are deficient. But in your response to that, I know that there is some health and family life education in schools. I'm not too sure, again, the extent of that curriculum, at what forms it is taught. But also, there are also counselors in schools that I'm sure children can rely on to have confidential conversations about sex and everything that's happening with the changes that they're experiencing at that age. So, Ms. McQueen, in your opening salvo, and speaking to those deficiencies, that's something I want you to pick up on as well.
Okay.
If you can just, there you go. Go ahead. Yes.
All right. So I am happy that Dr. Frame spoke about so many of the gaps. One of the other gaps has to do with that medical practitioners have, in fact, so before I get to education, I just want to pick up on that.
Yes.
Medical practitioners have also been reporting that they have had to deal with instances of suicide attempts by adolescents linked with the whole idea of stigma and discrimination and so on when it comes to judgment around sexuality. They have also reported instances of sexually transmitted infections, which the Ministry of Health told us about publicly a few weeks ago. We've learned from them as well about failed abortion attempts, where adolescents in particular use questionable means of trying to have an abortion. We have had stories around parents requesting virginity testing for their adolescent girls because of some suspicion around sexual activity. Virginity testing is a violation of human rights, and it has no medical value. It does not indicate whether or not a person is in fact sexually active. This notion around the hymen and all of that, it's not a real test for anything, but some parents are trying to insist that medical practitioners do some sort of testing with that. So generally as well, and this will link into the education side of it, other service providers who work with children have reported that few abused children seem to know that they were actually being sexually abused when the abuse started or when it happened. Many of them get to figure out or learn later on that they had been abused. As a matter of fact, adults who have been victims of child sexual abuse have indicated that when they were children, I'm talking about when they are adults now, they are saying that they were sexually abused as children. They knew they were uncomfortable. They knew that they did not like being around a certain person, but they did not realize that it was in fact an abuse and that they could have done anything about it or could have told anyone about it. And so this lack of knowledge is another aspect of the conversation that would be addressed, we believe, by having the bill passed into law so that it opens the opportunity for additional adults to be able to speak with children about issues surrounding sexual and reproductive health. Now, there is a general fear in the society of talking about sexual health, sexuality, reproductive rights, and all of the issues around it. except when it is around carnival time and the songs are singing and everybody has sexual, well, everybody is stretching it by far, but certainly a lot of us have a lot of sexual innuendos through our music, our lyrics, our costuming and everything. So apart from that, there is no real conversation that our society has, or children or adults are having around sexuality and sexual health. Instead, what we see is fear, judgment, stigma, and punishment. Now, that links it to the question you asked specifically about the health and family life education program and sexuality education in schools. Now, for quite decades, actually, health and family life education has been in schools. The program includes sexual and reproductive health education within the curriculum. It is described as age-appropriate health education or sexuality education. Age appropriate because it starts whilst the children are quite young in primary school, and it is expected that every year as the children go through the health and family life education program with their teachers, that additional information will be provided. Very basic information while the children are infants, and as they grow older, by the time they're middle childhood, 8 to 12 or thereabout, they should be getting some additional information. And when they get to early puberty, 11, 12, 13, and so on, they should have additional information provided. And of course, into their teens, almost the full gamut of information should be made available to the children. Now, the teachers are products of the Grenadian society. And the fear that I spoke about, the reluctance to speak about sexuality and sexual and reproductive health and rights is also a factor in the lives and reality of the teachers of the schools. We also have a situation where many of the schools are faith-based schools, faith-based management of the schools. And they too have an input on the content of the school curriculum that is allowed within quote unquote their schools. Even
right, which I think is such a contradiction, because here you have these faith-based schools, they have the boards and whatnot, but they're being funded by the state. So that, in my mind, is a contradiction. They're funded by taxpayers who may not even belong to that particular faith. With no apology, I say this as someone who believes in the separation of church and state. Yes, go ahead.
Yes, and the teachers are paid by the state, and sometimes someone who is not a member of that faith cannot get a job, even if they would be paid by the state. But that's a conversation.
That's a whole other conversation that needs to. Yes, absolutely.
But certainly, the management of the schools do have an input into what the curriculum, what is permitted or not permitted. That together with the stigma and reluctance and fear that our entire society deals with or is not dealing with, puts a great barrier on what is actually delivered within the health and family life education program. And research has actually shown that the greatest, that there is the biggest barrier between the curriculum as written and the curriculum as taught.
So, and Cassandra, I promise I'll be bringing in you next. I do, but again, I just want to piggyback on unpack something that you just said in respect of what is in the curriculum versus what is being taught, and that gap. Are you suggesting that there are elements of the HFLE curriculum that, for example, addresses some of the health challenges that you're just speaking of? So, for example, consent. So, for example, what to do if, around condom use and contraception use and things like that, right? Are you saying that the HFLE curriculum includes those elements, but that it is not being delivered?
I am saying it, and I'm saying that it includes it at age-appropriate levels. So some of the topics that you've mentioned would not be expected to be seen in the HFLA curriculum, the program for a 7-year-old.
Primary school. Yeah, of course not. No,
but
yes.
It is expected to be there for a 15-year-old, right? So it is age-appropriate. And I'm also saying that the information is available, but that information that can be provided by the HFLE program would be quite generic. It will not be individual specific. It will not be tailored to suit the need of a particular student, right? That is where health information, healthcare services and support need to come in as well, because in the medical sector, their approach has to be based on the individual before them, the individual client or patient, right? And issues around menstrual cramps, around how heavy the flow ought to be or is, and so on, issues around wet dreams, all of these issues, they might be mentioned in a generic sense in the HFLE program if it is taught in detail, but an individual's experience of those things and how it affects their lives will not be addressed within the school setting. It will be addressed in the healthcare setting once that becomes available to them.
And the gray area here is that in the context of the healthcare setting, those conversations cannot legally be had by the health professionals unless a legal parent, a parent, of course, the legal parent or guardian of that child is there.
There is a gray area, as Dr. Frame said.
Yes.
The law, there is no law that, in all the research that was presented to us, there is no law that specifically says that it is illegal to do so. But because there is a law that says a person is an adult at 18, that is the Civil Responsibilities Act.
Right, and that is another contradiction.
Is there.
Correct. And that is another contradiction that we have to resolve. But Cassandra, welcome to the Bubb Report. It has been a while, but it's such a pleasure having you here for this conversation. And again, I want to begin, I want to begin with the same question that I posed earlier. In respect of the current deficiencies, big picture now, as someone who has worked in the gender space, as someone who's worked in the of course, the women's space, if you will, not only women, but men, you're also an advocate for men as well. Let me not forget that. In respect of those deficiencies, big picture, what are your thoughts on that? Because I think that ought to set up the conversation, the rest of this conversation.
Oh, yes. Good morning again, and thank you for the opportunity to share this space with these brilliant women. And I want to support what Dr. Frame and Mrs. McQueen are saying in terms of the gaps in the healthcare sector. I think from a civil society perspective, no one is disputing that these gaps exist. For us as civil society advocates who work in the gender space, work with women and youth, one of the many challenges that we have is, of course, the financial constraints, because a lot of the times we are the first point of contact for victims of sexual crimes. They come to you in the community because they know you work in the space, hoping and obviously looking for access to services or referral to services, some support. But we as civil society, we do have face our own challenges in regards to financial constraints, for instance, and unpredictable funding. So while we do work and do offer some sort of sexual and reproductive health services like condoms, access to condoms, some education, counseling support, depending on what the mandate of our organization is, we are working as civil society in a space where there is unpredictable funding. And we are, while we shouldn't be, we are competing with very limited resources. So many NGOs tend to work with a small group of people, small group of resources. And while we fill in some of the gaps in terms of service delivery, because no one is expecting government to provide all of the services, we have to face that. And policy, one of the things that the challenge that we have is that when we try to contribute to policy, there is a general perception that if you do not support a policy by local government, that somehow you are anti-government. So some CSOs have to deal with that as well. But we're not disputing that these gaps that Dr. Frame and Ms. McQueen has highlighted do exist. Like she said, one of the things that we have been going back and forth with in terms of the legal gaps. So you have healthcare providers who may provide services for minors who come to them. We provide we have some challenges in terms of the contradiction between existing laws. I have had encounters with healthcare practitioners who have said to me that while they're willing to offer support, one of the challenges that they face is that a lot of minors under the age of 18 are coming to them. And of course, I know that our Child Protection Act does define a child as someone 18 years and under. So for a lot of healthcare providers, while they're open to providing some education support services, there is that fear that they need the consent of the guardian in order to provide certain services. So we are not disputing that exists. I want to address something that Mrs. McQueen said in terms of the most of our schools being faith-based schools. We have to also accept that in our constitution, we do have protection of freedom of conscience, which speaks to allowing individuals that right to their own religion, teaching practices. And within that particular clause in the constitution, it says explicitly that the state, which is the duty bearer, cannot provide certain services in terms of religion teaching practices to someone who is under the age of 18. It says explicitly, I think in sections 9, subsection 2, that the consent of the guardian is needed. So for those who have been in the different space, social sector, health sector, that's one of the things that they consider when they engage and interact with minors who try to access health services.
Mm-hmm. But on that question, I'll bring in Ms. McQueen here. On that question, again, I want to pick up quickly, and then we'll get on to the other question. On that other contradiction in my mind, because there's a lot of contradictions that we will talk about today. On the question of freedom of conscience, Cassandra, are you suggesting, so for example, I can use, because I attended the Presentation College. I know, for example, in Presentation College, if you are not Catholic, for example, then you are not required to go to a Catholic mass, say on Presentation Day, which is the feast day of the school. But I think what Ms. McQueen was referring to here was specifically in respect of the say-so that the faith-based organizations have in respect of what is being taught around the whole question of sexual health, sexual and reproductive health.
No, yes, and I agree. I think I understood what she was trying to relay. But when you look at section 9 of the Constitution that does speak to freedom of conscience, it says that a lot of people who are affiliated to certain denominations may use their religious affiliation to say that, I don't want to mention any denomination for fear of feedback, but may use their faith, their affiliation to say, I don't want, because I am a John Doe or Jane Doe, I do not, our denomination or religion does not allow for the school where your children attend to be taught sex education based on your denomination or your faith-based affiliation. And it says so in the Constitution that you have to respect that. And if you are to teach someone who is 18 years and under any practice teaching that is linked to their denomination, their religion, then you must seek the consent of the guardian. So I understood what she was saying.
Right.
From experience, of a lot of parents who will use the, I don't want to use excuse because you have a right to affiliate to a denomination, but they will use
of course,
their faith.
Religious freedom is in the Constitution.
Yes. They will use their affiliation to say that I do not want my child to be taught these topics in the school, because it is not part of our religion, or I feel uncomfortable with it. And you have to respect it, because I think there is no ambiguity when you look at the clause, section 9 of the Constitution, that consent is needed from the guardian as it relates to freedom of conscience. And freedom of conscience does encompass religion, denomination, teaching practices, etc.
Ms. McQueen, is there anything else you wanted to piggyback on to what Cassandra just articulated?
Yes, please. First of all, the article in the Constitution to which Cassandra referred is Article 9, and it does, as she said, speak about protection of freedom of conscience. The particular clause 2 that speaks about religious, about consent for a parent in the case of someone under the age of 18, speaks specifically about receiving religious instruction or to take part in or attend any religious ceremony or observance, if that instruction, ceremony, or observance relates to a religion other than his or her own. So this clause in the Constitution does not speak to health education, mathematics education, space or science studies, or anything except religious instruction, religious ceremony or observance, if those are different from that of the parent or guardian or the child. Who determines what the child generally, what the child follows, right? The Constitution also has an overarching set of guidelines. In the very first chapter, the first the first part, this is part of the first part as well, but Article 1 of Part 1 also speaks about ensuring the state has the responsibility to ensure that the rights of everyone is upheld, right? And it gives the permission to the state to make law, to determine what is the public good, right? In the public interest, that everyone has the constitutional rights, everyone has equal rights, but everyone's rights is subject to the rights of others, respect for the rights of others, as well as the public good. And the state can make legislation and has been making legislation around a whole myriad of things that determine what is the public good. And also, when does someone's rights start to infringe on the rights of others, okay? So, be that as it may, the state recognizes, has indicated anyway, that it recognizes that not all children everywhere in Grenada has access to health, sexual health and rights education and services in other spaces, and that there is a gray area around sexual and reproductive health and rights treatment, diagnosis, and education and services as it relates to the healthcare spectrum, right? And that these gaps need to be addressed. The state considered the documentation, the reports, the stories that were shared, the examples of their own lived experience, of the lived experiences of the leaders of the state as well. And they are saying to us that they are willing to take, and they have tabled in Parliament, this bill that says that there is another option. It's not a mandate that every child goes to a healthcare center to get sexual and reproductive health education or treatment or diagnosis or anything. It's an option that now can be available. Should a child, should an adolescent need that service, should that adolescent want to receive that service should be available to that child in a safe, professional environment that the healthcare sector is expected to provide. Alongside that, state says that it is putting in policies and other procedures that will support and guide the healthcare sector on how those services can be and should be provided.
Yes, and Ms. McQueen, yes,
and adolescent health policy
yes.
are involved.
Yes, and stick a pin there, because I do want to bring back Dr. Frame into the conversation, and we are going to talk about how we will get to, I suppose, a place of resolving a lot of the contradictions that I opened this conversation with. And really that has to do with what Dr. Frame, you articulated earlier. And that is the question of healthcare providers, medical providers saying that, well, I cannot provide that type of medical care that particular adolescent may need in a manner that would assist that adolescent, right, because of that particular gray area. But here is another part of that gray area that I'm considering, and that has to do with the recent decision to increase the school age from 16 to 18, right? So in the context of increasing the school age from 16 to 18, how then do we treat with this question of access to medical services at 16, and in some cases 12, we'll get to that question of 12 later, but at 16, when the school age, some parents may say, well, the school age is 18, so therefore, as a parent, I ought to have autonomy over my child's decisions. Dr. Frame, what say you on that question?
So again, another important question. I would say here, it's not really a contradiction. I think what we have to understand, I myself, I'm a parent of young children. And so I think, hopefully speaking, I can also now speak from that perspective.
Okay.
Right? But it's really about, again, protecting the children. Adolescence, so maybe let's start with the definition of adolescence. That could potentially help, yeah? So when we talk about adolescence, we talk about, if we put an age definition to it, we're talking about the age of 10 years old to 19 years old. It's a broad age range. Right? And it's broad because it's a developmental stage where adolescents are going through a set of transitions, emotional transitions in the way that they're thinking. A 10-year-old is not going through and experiencing the same kinds of transition a 10 to 12, 13-year-old. That's early adolescence, right? They're having a very different experience from those who are in the middle adolescence, those around 14, 15, and boys, and there's some overlap in these ages because we know that boys and girls, there are sometimes in that developmental time span where girls develop faster than boys, and then boys come in and they overtake girls in the developmental process, right? So there's some overlap in that time, that developmental stage. And then you have your late stage of adolescence. You're 17, you're 18, and you're 19 years old. Very different stages in thinking, in behavior, level of responsibility, and so on. But it's largely a stage where they're experimenting because they're trying to find their identity. They're trying to figure out who they are, right? And so we have to make allowance for that. And so it's the stage where parents are now starting to let go. And it's difficult to let go, right? But we have to start to let go because we're preparing them for adulthood, for taking on these full responsibilities. Now, one of the things that has caused some of these changes, I'm only informed of the reasons, why the age was changed for schooling from 16 to 18 through what I've heard in the public debates and so on.
And that is because 16-year-olds cannot legally work. I think that's a big part of it. And there's some other deficiencies as well, but go ahead. Yes.
As of course. Yeah. But what also is happening now in my parents' generation, right? My parents are in their 60s. In their generation, adolescence or puberty, that period that defines when adolescence starts, that period started much later. So you had girls experiencing their first period, right? Maybe at 13 and so on. Now, you have girls who are experiencing their first period at 8 and 9 years old, right? That comes with a lot of changes in your body, right? Sexuality is something that we're born with. It's a normal part of life. So you see babies touching their private parts, they're playing with it because why? It feels good, right? So we have conversations with small children to say, okay, that's your penis, or whatever we call it locally, right? Or that's your vagina. We say saltfish and we say cocoa and we say whatever, which goes back to Miss Henry McQueen's point that sometimes children are experiencing abuse and they don't know it because ask them what they experience and where they experience it, and you're waiting for them to say vagina and penis and they cannot. They're saying saltfish and cocoa and different kinds of things, right? But puberty starts much earlier now. So they're having these experiences of all the changes and they don't know what to do with it much earlier than they would have several generations ago, right? So we have to start preparing our young people for adulthood. This conversation is not detached from the same conversation that we hear when Ministry of Education or private sector talks about the education sector is not preparing our young people for the workforce. Our young people have 12, 13, and 15 subjects, but they cannot perform in the workplace. It's because we have to give them skills. We have to not just give them the academics, but we have to give them skills to perform, to live and thrive and excel in the real world setting. And it is no different when it comes to sexuality, right? And so these are a set of protective measures that are needed, like I said, not just for sexual and reproductive health and rights, but for adolescents' health and development and well-being, but also for the development of our country. Take a very simple example. And you have parents who are working. They need to go for their annual check. Remember, most of our households are female-headed, single-headed by women. This woman, most of our people are not earning a very high income. The single mother or single father has to take some time off work, potentially a whole day off, to bring their son or daughter to see a healthcare provider. Why? Because access to healthcare services is not just limited to access to healthcare, to sexual and reproductive health services. The age affects access to all health services for adolescents, right? So why is it that a parent can't say to a child without expressly giving them a written consent to say, okay, your appointment is such and such time, go and see the doctor. If there's anything that the doctor needs to call me about, they can call, right? Or in preparation for adulthood, let's say around 15, 16, and based on the maturity of your child, you can say, you know what, call the doctor and make your appointments because you're now preparing them for the real world of when they are on their own and they have to make independent decision, but also take independent actions, right? So I understand and appreciate the cultural context where we're coming from. We have had a history of not talking about this, right? I have not had a conversation growing up with my parents. Mommy, I love you, but we've not had this conversation, right? As an adolescent growing up. Many of our young people we're still in the stage where, they're growing up with relatives because their parents are away, trying to make a better life, or the parents they're not the most responsible type of parents, right? So there's a concept called the best interest of the child. And so when we make these decisions, we are making these decisions in the best interest of the child. It's the same situation where the Child Protection Authority can enter into a household and remove a child without any consent from the parents because they believe it is in the best interest of the child to do so, right? This law is saying we think it is in the best interest of the child, of the adolescent between 16 and 17 years old, because 18 is already given based on the age of majority. For 16 and 17 years old to have access to these services. They're already having sex. They can make decisions about having sex legally, right? Why shouldn't they be able to make decisions about protecting themselves? Right? So I don't think these two things are very different. And I hasten to add that this law does not prevent any parents who wants to go with their adolescents to access these services.
But except it assumes a context of confidentiality, an empowerment on the part of the child to retain confidential information when they have conversations with their physicians, does it not?
It will, but that should happen in any event. So let me explain, right? When you have an interaction with a healthcare provider, the best practice will tell you that the healthcare provider should always take some time to have some conversation with the child, with the patient alone. If the patient is accompanied by someone, right? Because there's always some information that the patient may not be willing to share, to disclose openly with the healthcare provider if someone else is present. So this applies to the encounter with the adolescent. This is part of if a husband and a wife go to a healthcare appointment together, right? If you take an elderly parent or relative to see the doctor and they have their mental capacity and so on, a healthcare provider reserves the right to ask for a conversation with the patient alone. And so what this law does, even if the parent goes with the child, the parents, and they can negotiate. There's something called informed consent. This is a fact of life and a fact of how the relationship with the healthcare provider operates.
Yes.
Right? So if the child is comfortable and you say, okay, they show up together, are you okay having your parents here? Yes, I am. As they go through and they negotiate the consent process, because consent doesn't only happen at one point in time, it happens throughout the entire experience, right? So something else comes up and you want to do something, you want to ask maybe a particularly sensitive question. You want to ask the question, have you ever been sexually active? You may say, again, before you ask that, you can say, maybe, okay, I'm going to ask you some sensitive questions about your sexuality or what have you. Would you like your parent to stay or would you like me to speak to you alone? right? So there are strategies in dealing with this. It's called framing questions, right? So there are ways. This is not new. This is not unique to Grenada. And I can tell you that there is already plans in place for training in what's called adolescent responsive services. Now, prior to this bill, I have done these trainings before with healthcare providers in Grenada. And it's a very kind of theoretical experience, because at the end of the training, you know that healthcare providers are going back to essentially doing what they were doing before they came to the training, because they didn't have the legal framework to implement any of that. So it's knowledge that maybe when a parent and a child come together, they are able to utilize. But the real power of that training is when the adolescent come alone. When the adolescent come alone. So this is not a situation where, we are exposing adolescents to the vultures in the healthcare system who will abuse them. I am not saying that there may not be some predators within the healthcare system. It's a fact of life. Predators are everywhere. So let us be honest, right? But what this does, it now creates this space where we can put things in place to ensure that our healthcare providers are trained, that they have the tools that they need to provide these services that meet the needs of the adolescents, right? And this is about the adolescents. There is a space for the parents. Let's say an adolescent comes in and there's a positive HIV test. Now, the question you're going to ask is, so where is the parent involved in this, right? And that's the big fear, that these things are going to be happening to your beloved son and daughter, and that you're not going to be involved. That is not the case, right? The best practice will tell you that this is a process where the healthcare provider will have to negotiate and have conversations. There's a lot of communication involved in this. And the healthcare provider just won't send the child away and say, well, up to you if you want to tell your parents, that's your business, right? The healthcare provider will engage the child, the adolescent, in the conversation and work with them to have whatever conversation they need to have with the parent. The questions have come up in consultations, right? So we've talked about this in consultations with various sectors. Well, what happens when they access services that they need to buy medication and all of that? They don't have any money. Where are they getting the money from, right? So it tells us either the system has to provide the treatments and so on for free, which brings in the conversation around universal access, universal health care, universal health coverage. If we're making the services available, how do we pay for it, right? Who is paying for these services? Will parents have to pay for it? Will the state pay for it? How do you get the parents involved? So these are all of the things that now we will have the space to have discussions and put systems in place for implementing this. This is work that I've done locally, and I'm telling you, there are steps, there are mechanisms, this is not unique to Grenada. There are Caribbean countries who already have the age of 16 as the age to access sexual and reproductive health services. Jamaica is an example of that.
Yes, stick a pin. Let me bring in Cassandra here. Cassandra, you've heard what Dr. Frame articulated here. And Dr. Frame, I suppose, preempted some of the countervailing narratives, if you will. I would not necessarily call them narratives, but realities, really, on the ground realities that can occur. So, Cassandra, I want you to pick up on what you just heard. Viewers and listeners, you are watching the Bubb Report. We'll be back right after this.
We seek the truth.
Would you be handing your resignation to the Minister of Culture tomorrow, sir?
No, I will not.
The leader of the opposition, you have accused your government, sir, of using the Grenada Development Bank to facilitate the financing of personal loans for certain government ministers.
The other side is in no position to talk about those issues, and I will leave it there.
We discover new perspectives.
You know his leadership style, and so many are saying, why are you coming now to talk about those issues?
Now is the time to speak. You have the right to decide who will take over.
And you met with Dr. Mitchell, and perhaps you might want to confirm what that meeting was about in your response. But
Dr. Mitchell, like myself, are Grenadians.
We ask the right questions.
Why was there no report on the work done of the commission? And how is this new committee different from the commission that was initially established back in 2022? So who are these elements that are using you?
I'm disappointed in my political leader.
And why is that animating those political conversations now?
This is a very interesting question.
The Bubb Report with Dr. Kelon Bubb. Thought-provoking, truthful, unbiased, and truly original reporting.
Should your loved ones pass on, they deserve to be treated with dignity. And at S.A. Johnson Funeral Home, we can provide you with that service. We can take you every step of the way during your sorrowful moments. When that need arises, call S.A. Johnson Funeral Home at 347-777-9797. That's 347-777-9797. S.A. Johnson Funeral Home is a Caribbean family-owned funeral home here in Brooklyn, providing funeral services, but in a dignified way. From cremation to burial to the repatriation of your loved ones, you don't have to go through the hassle, as we provide exceptional service that allows you to mourn and heal peacefully. For more information, visit our website, www.sajohnsonfuneral.org. Send us an email at sajfuneral@aol.com or call 347-777-9797. S.A. Johnson Funeral Home, because you deserve to be treated with dignity.
Yes. Bob, Dr. Fim, I listened to you for the last few minutes, and I'm a parent myself, and I started to feel very uncomfortable, very uncomfortable. Again, we are not disputing that these realities are, but I'm listening to you explain this, and I'm asking myself, well, how does an act of parliament solve what is obviously centuries-old embedded cultural attitudes that we have come to accept? How does it solve that? I listen to you actually justify, oh, well, there are predators everywhere. One of the things that I raised when I raised concerns about what I saw, the clauses within the bill, was the immunity clause. So I heard you continuously emphasizing on 16 and 17-year-olds, but you have failed to address the fact that this new amendment to the Civil Legal Responsibility Act also gives the minister the authority in special circumstances to allow 12-year-olds access to sexual and reproductive health care. One of the first thing that pops into my mind when I read that is, why wasn't the individual, because no one is disputing that 12-year-olds, 11-year-olds are having sex, and maybe as young as 8, 9-year-olds, but why give the responsibility to a minister that is a non-neutral office to make that decision? How are we as parents going to be comforted that if one may be of a political affiliation, that the minister may or may not grant that order and is going to be neutral and unbiased in his or her decision? That's that. I heard you and I agree totally that the maturity stages and phases of each child is different. Then how does the medical practitioner, through this legislation, address that? Is there a particular test that's going to be done to determine the mental capacity, the maturity of that individual child? And then I heard you mention about obviously access to reproductive and sexual services, but the cost. These are still minors who many times are still residing with their parents. You're correct. Who is going to pay for it? if we go back a few weeks ago, a member of parliament on another platform is noted as saying that he saw no need to purchase medication for the hospital because in developed countries, citizens tend to purchase medication themselves. I have seen nothing in the legislation that comforts me as a parent, first and foremost, that the state is provide allocation for funding to provide contraceptives and other financing to pay for these services that we are now, through this legislation, going to give our children access to. And again, I want to go back to the immunity clause because you're right, the predators exist everywhere. If that immunity clause exists, what happens if a 12-year-old consent, and according to that law, that 12-year-old is now considered age of full civil legal capacity, and there is a mishap? Who is going to be held accountable? The minister, since he or she gave the order? Is it going to be the medical practitioner? Is it going to be the state on a whole? And I think these are valid questions that we are raising as parents in regards to this new amendment to the legislation. And I listened to you and I became very, very uncomfortable when you seemingly nonchalantly tried to dismiss almost the concerns that was raised over the last few days in the public. These are children. And in light of the state of our health, and we are not disputing, of course, we see it in the data that 75% of the cases brought before the judiciary approximately are sexual offenses, many of them children, minors, many of them women. But how are we addressing this? I'm very uncomfortable with the discussion because I read the legislation and the amendment, and I also took the time to look at the Principal Act. I removed the old section. I inserted section 4A, which is the new amendment, and I read it as a new legislation. I'm even more concerned because some of the clauses that were not amended will now apply to this new lowered age of civil legal responsibility. And again, and that is something that as a parent, first and foremost, even before I wear the hat of a civil society representative, I don't think that the legislation is addressing, and I'm not hearing it being addressed by you, because all I'm hearing is the cart before the horse, where you're saying that there are plans to do training. Why wasn't training done before? And then the state, as a duty bearer, come to parents and say, look, we have trained 25 professionals to deal with adolescent health. Based on the data, we are seeing that there is a problem that needs to be addressed immediately. Like Dr. Bob mentioned, inconsistencies in the legislations that do exist. We have a Child Protection Act that defines a child as someone who is 18 and under, yet we have the age of consent in the criminal code as 16 years. And then you have the amendment to the Education Act, which now raises the age of compulsory education. So there are a lot of inconsistencies, and of course the age of criminal liability, which is 12. So there are a lot of inconsistencies in legislations which do exist. Even when you look at the Principal Act that was amended and you read it in its entirety with the new amendment inserted, there are concerns in regard to exactly what 12-year-olds or 16 and 17-year-olds are given the legal capacity to deal with. And you're correct, a lot of them, their maturity phases are different. So how do we?
There's so many gray areas around that age, around that period. So many. Yeah. But Ms. McQueen, I want to bring you into this conversation, of course, and I'll get Dr. Frame to respond to a lot of the concerns that Cassandra raised, especially in respect of informed consent, because as researchers, we know that as a PhD trained researcher, you know that informed consent comes with risks that you have to state what those risks are, right? Especially when you're dealing with human subjects. Going back to my IRB days, I still do. But Mrs. McQueen, I'm sure you've heard this concern here. What happens there? Address this question of consent. One, in the context of the consent now that child is giving to a physician, and the risks that may be associated with, along with the other concerns that Cassandra just raised.
Sure. I just want to reiterate the last point, I believe, that Cassandra raised, and that is to do with different ages for different things within the adolescent period. The age of criminal liability is 12 years old. So we're saying that at 12, a child is able to be prosecuted in a court of law for a criminal offense, and that child has enough sense and responsibility to be able to charge with stealing, murder, rape, anything, any criminal offense that and that up until recently that child could be sent to prison. We note, however, that that age was raised in 2012 or thereabouts in the Juvenile Justice Act. It was raised from 7 to 12, right? So we accept that at 12 years old, a child has sufficient sense to do some things, including committing a crime. So we already accept that in law. We accept in the sexual offenses section of the criminal code that if a child under the age of 13 is sexually abused, the penalty is maximum of 30 years in prison. But if a child between the age of 13 to 16 is sexually abused, and basically it's 13 to under 16, so it's 13 to 15, that the penalty, the maximum penalty is lower. It's 14 years, right? Therefore, it means that we are saying that from the age of 13 to 15, the child, though sexually abused, does not, I shouldn't say the child, but the person who abused the child, though still under the age of 16, does not have to face the same level of penalty if found guilty, right? And then we're saying that a person who sexually abuses someone who is 16 to 18 does not fall under the section that deals with sexual abuse of a minor, which quote unquote minor is defined as 18 in other areas, but they can be charged, of course, but under rape, sexual assault, and so on. But it does not automatically mean that there is, well, what it means is that the idea of consent comes into play. And therefore, if a person says that he or she received consent of a person 16 to 17 years old, and they can prove that that consent was real and so on, then there is no automatic charge with a criminal offense. Okay? Now, clearly, we recognize, and joining that to what Dr. Frame said earlier about different stages of development of an adolescent, we clearly recognize that adolescents of different ages can do certain things and can have certain responsibilities. In the homes, we know that. We know that we will not ask an 11-year-old child who is already an adolescent to take care of a younger sibling for an extended period of time, but we can do that with a 17-year-old, right? We know that we will be very cautious if a minor who is under the age of 13 or 14 has to cook something, do eggs, make tea. We have to monitor them. But if that minor is 15, we expect that certain things they should be able to do quite comfortably in the kitchen without burning the house down, right? So we all know that different ages carry with it different levels of responsibility. Though with their adolescence, everything does not apply. The same level of responsibility does not apply. The level of maturity has to be taken into account. All right? And that is not different in the case of the age of civil legal responsibility and the amendment that is offered. Now, a concern was shared that the bill says that a person shall not be subject to criminal or civil liability for administering, if they administered sexual and reproductive health treatments to a minor. Now, one word was left out, both in what was said earlier and in what I just said, and that was solely, right? Article 6, well, Section 6, Clause 6 of that amendment says a person shall not be subject to civil or criminal liability solely by reason of having administered sexual or reproductive health treatment to the minor with his or her effective consent in accordance with this section. Solely. Solely means only. Now, if something happens that is negligent, then obviously all the other things to do with civil and criminal liability can kick in. But a person, a parent, a guardian, a neighbor cannot charge or seek to charge, take to court a medical practitioner and charge them with some criminal liability or sue them for some civil liability simply and solely because they provided medical services to a child, right? Sexual and reproductive health services. If something else is with it, yes, you can. Somebody can be sued if there is negligence, malpractice, whatever, but not solely for providing the service, right? So once we include that word, we see the protection there. When we talk about a child between the age of 12 to 16, based on the provisions that are offered in Parliament, it says that an order, that is an order to be considered by the Minister for Legal Affairs in conjunction with the Minister for Health, must be subject to a number of things. One, the minimum age of the minor to which the order applies. So it doesn't have to be 12 in all circumstances. It could be 13 or 14 or 15, right? That the specific health or reproductive health treatment must be identified. It's not the full range automatically, right? And that any conditions or restrictions to be imposed can be included within that order. And that is in the amendment, right? So the ministers are not being given like an overarching carte blanche, do as you may thing. They are given guidance within the legislation, the proposed legislation, that says these are the parameters with which you must work. And an order under this section must be subject to affirmative resolution, right? Now, it has to be agreed with in the affirmative. It's not that they just do anything without consenting the other ministers, the parliament, or anything. There are provisions in there. In the case of, that is, in the case of those persons who are 12 to 16, right? Now, it is therefore very clear that the law, the proposed law, seeks to correct a problem. It seeks to give options to people who need it most, the adolescents who need it most. And it also seeks to ensure that provisions are in place to put guardrails, protections, so that those options will not be used indiscriminately, right? And that is why I have no difficulty in supporting that proposed legislation. You see, the most vulnerable adolescents who really need these services are those who live in households with multiple and intersecting forms of discrimination and marginalization, right? Those who need it most are likely to be those who live in households with young single parents, not I'm saying young single parent. The parent is young and single, right? Or it could be a couple, but they might be young and inexperienced parents. Some are in households with uninformed parents, parents who do not necessarily know how to speak with their children and give support in relation to a range of issues, including sexual and reproductive health and rights. But because the stigma and fear around talking about sexuality exists, even in the sorry, did something happen? I saw something saying my screen
No. I was attempting to share the legislation. I'm trying to share the screen. Go ahead. Yes, please. Go ahead. Yes.
Oh, okay. All right.
Yes.
Yeah. I was speaking about the most vulnerable children, the most vulnerable adolescents are the ones who are living in households with young single parents, uninformed parents. Sometimes the parents themselves are in poverty. The family, the household is in poverty. And it doesn't mean that people living in poverty are automatically uninformed and so on. What I'm suggesting here is that people living in households that are not in poverty tend to have more options, right? They tend to have more options that they can pay for, private medical services and so on, including that for their children, for their adolescent children. And the adolescent children, tend to have wider sets of options available to them. The people living in poverty might be only able to access healthcare services from the services provided by the state and by places like the Planned Parenthood Association, but they're not likely to have access to other ways of getting information and services and treatment and advice and counseling. Many of the time, they have fewer options, very, very limited options. So the children we have observed also, for example, children who have had children, say a 14-year-old girl who has a baby, is pregnant, has a baby. If that child is from a household that is classed as non-poor, according to the poverty survey, a non-poor household, especially those in the upper quintiles, like the wealthier of us in the socioeconomic ladder, the child might not even experience the pregnancy within Grenada. They have the option to take them abroad, they have their child, they continue their schooling, they continue to university, they come back home, them and their child. Sometimes we get to find out all the way when they're 30 or 40 years old that, oh, this person I thought was their sister or brother or niece is in fact their child, right? Someone from a poor household who is unable to have that kind of option will be in Grenada trying to access healthcare services, cannot know what to do. Parents are threatening them. They're thrown out of school. They're threatened to be thrown out of the house. And in some cases, of course, but I'm speaking about the most vulnerable of the loved ones. They're going to the healthcare providers. The nurses are not sure what to do, and so on. So let us start recognizing that when we are seeking to address issues like this, we're not only taking into account the parents who are able to give advice and support to their children, because we know many parents can do that and are already doing that. And those children will perhaps not need to use this legislation at all. There are lots of legislation in place that people only use when needed. This is one of those. A child who is in a most vulnerable situation, they cannot get the support or information from their parents. They can now get it from a medical care, a healthcare provider. I see the section you have highlighted, Dr. Bubb. Can I ask you to go to the actual clause to which I was speaking? It is
and Cassandra, I want you
4.
to also help me here. Are you referencing a clause? Because I think I just have the. Let me go back to the Parliament website. And Dr. Frame, I have not forgotten about you. I'll be getting back to you shortly as well, so that you can respond to Cassandra here as well. So bear with me here. What clause do you want me to go to, Ms. McQueen?
It's the clause that you highlighted, but what you highlighted is a summary. If you go
That's
to
just
the
a summary,
actual,
right?
Yes, if you go to the actual text of the proposed legislation.
Okay, let me find the text
page
here.
4.
Let me pull it up. Yes. So while I'm searching for it,
the same document.
Yes. While I'm searching for it, just proceed in the meantime. Just tee up what you want to say. I will pull it up here. Yes.
All right. Sure.
Yeah.
So we've considered and advised and supported the government in relation to this amendment because it will address those burning issues, but also because it will take some precautions and embed some precautions in place so that this legislation will not be indiscriminately used, so that children will be protected, but also that the ministers, in considering what to do about the children who are younger than 16, have some guardrails in place, and also that the healthcare providers will now have a sense of certainty that the mere discussion with a child or provision of services will not open them up to lawsuits just for that purpose. Of course, they do have to take all the other normal precautions have them in play, because they're medical professionals, they're professionals, and therefore all the other things that go along with working in the best interest of the child, in the case of the child, in the best interest of the patient, the best advice, the best scientific evidence available. All of those things will be taken on board. And we also expect that, as Dr. Frame said, further training will be provided to medical care providers. And I say further training because trainings have already happened.
But Dr. Frame, while Cassandra logs back in, I want you to respond to some of the concerns that she raised, please.
Thanks, Dr. Bubb.
Yes.
So I want to start by saying that if it is not my intention to appear that I am dismissing the concerns, as I've said, I appreciate the dialogue. This is a wonderful opportunity. I think Mrs. Henry McQueen and myself and others who have been working in this area have longed for such engagement on this topic. And so it's not a matter of dismissing the concerns, but I think because this is the language that I speak, this is the work that I do, I am fluent in it, I understand it, and I don't have reservations on speaking about it. The way that I speak about it and the information that I share is based on years of work that I've done in this area on research. You yourself is an academic. I've done years of research on these topics, not just in Grenada, but I've done research in Grenada on adolescence. And the topic of my PhD thesis, in fact, was looking at the social and sociocultural and programmatic context of adolescent help seeking in Grenada, right? And so these issues, I spent years investigating and trying to understand these issues. So it is not a matter of dismissing the concerns, but what I want to do is to really take the population on an experience with me to understand what I've known and people like Mrs. McQueen have known for years based on the work that we do. So forgive us if we sound dismissive or nonchalant. It is not that. It is our passion and our understanding and appreciation for what this policy, this law means for the adolescents that it is targeted to. It is no slight against parents. It is no slight against our adolescents. It is meant to protect them and to care for them, right? And it is based in the evidence of what is known globally, what is known regionally, and we do have some data in Grenada to support the policy of this and then further the implementation of it. So allow me to share. Mrs. Henry McQueen addressed some of the concerns that Cassandra raised, so I won't rehash those, but I do want to share a little bit of data, right? The issue of sexual activity among our adolescents. It starts very early among some adolescents. In some cases here in Grenada, as early as 8 years old. Now, the data that we have is a little bit dated, but more recent data from other countries show that this is not unique to Grenada. Remember, I said adolescents start at age 10, right? So let me share a few bits of statistics.
Yes.
Right? Among adolescents ages 13 to 15, based on information from a study that was done a few years ago now, 37%, and these were among students in secondary schools, 37% of them had ever had sexual intercourse. That means at one point in their life, they may have had sexual intercourse just one time, but it counts. They may be currently at that time actively engaging in sexual activity during that time frame. It counts. Between 13 to 15-year-olds, 37% of them had ever had sexual intercourse. Boys, 43% of them were nearly 3 times more likely than girls. 15% of girls, right, had sexual intercourse compared to 14% of the boys in that 37%. Among those who were sexually active, 57% of them used a condom at the last sexual intercourse. And condom use was predominantly among adolescent boys, right? Now, based on some qualitative research that was done, it showed us that this lower condom use of among adolescent girls is likely attributed to the demonization of females' open expression of their sexuality, which then may inhibit girls from purchasing or negotiating condom use, as well as poor parent-adolescent communication about safe sexual practices prior to sexual debut. And I'm just reading this from something that I had written and presented to government, right? This is just on sexual behavior, right? We have a fairly high rate of adolescent pregnancy. We've seen increases and decreases in rates of adolescent pregnancy over these years, right? And if I take the numbers rather than the rates and I give you raw numbers, in any given year, there's probably about, let's say on average, about 105 pregnant adolescent girls right? I can give you more specific numbers, but I don't have it pulled up. So I'm just giving you a sort of average, and I'm giving you numbers and not rates, just so the population can get an idea of the number of teenage girls. Most of them are between 15 and 19, but you do have some who are younger, 13, and occasionally you have the 10-year-olds and so on, right? We also have been seeing an increase in sexually transmitted infections. In fact, the Ministry of Health has put out a recent press release on that among young people.
The statistics were alarming on that when I saw it.
Right? Further, I also represent the Grenada Planned Parenthood Association, which is a civil society organization. And as the president of that association, I can tell you, I have seen the data from our end. And we have had conversations about how troubled we are about the low uptake of contraceptives in the general population. It is very concerning. And so for us, when we saw the increase in STIs, because we see it at our clinic as well, we report those numbers to the Ministry of Health. So what they report is our figures are included in that. And so we're very concerned, because if people are not using contraceptives, even condoms, we expect an increase in STIs. If our young people don't have access, our adolescents do not have access to the health services, in addition, they are exposed to a barrage of misinformation online, on social media, on YouTube. They have to sift through to make sense out of nonsense. They are exposed to a barrage of pornography. They are exposed to a barrage of explicit sexual content in the music, in the movies, and they have no real outlet to talk about it with someone to help them to understand what is real, what is not real, so determine fact from fiction. Conversations about values. What are the values in your family around sex? What is acceptable and unacceptable? Do we have these non-judgmental exchanges where our adolescents feel that even if they had an indiscretion, right, that it is not the end of the world, and they can go and tell their parents will be upset, but they will respond appropriately, show love and care, and say, okay, let's go to the doctor, let's go checked out? Or is the response a world of licks, a world of cursing out, right? A world of punishment, while the child suffers in need of health services, right? Whether it is a contraceptive, whether it is treatment for an STI, whether it is testing for HIV, this is the situation on the ground, right? So I am not making up fantasies. I am telling you, this is the reality on the ground. And I am ecstatic. I'm ecstatic that we are having these conversations. And as Mrs. Henry McQueen said, the Grenada Planned Parenthood Association is willing to accept the bill as it is presented because we know what is happening on the ground. The current status quo is putting our young people at risk. It's putting them in harm's way. what this current law does, it does not go far enough, but it begins to address the harms that our young people, our adolescents, are exposed to when they do not have access to services. So keep in mind, I am a public health faculty. I teach a bunch of students, and in 90% of my lectures, I start by saying information and education are not enough to change behaviors, right? And Dr. Bubb, you know this.
Yes, from health communication, yes. I say that to my students too. Yes.
Right? So we must be armed with the skills to change the behavior in order to implement the knowledge that we have learned, the new knowledge that we've learned. We must have an outlet to be able to implement it. Otherwise, the whole thing, in my view, then is unethical, right?
Yes.
So if we are giving all of this information, the GPPA in recent times, we've started in June, we've started going to the parent teachers associations, and we intend to continue, not knowing that government had this bill in their back pockets. But we, knowing what we know, we started going to the PTAs because we recognize that parents need to be engaged, and because for far too long, they have not been. Right? And so as a result, we have started engaging the PTAs to try to help them to understand that they need, there's a need for adolescents to have access to these services. And GPPA provides a safe space where parents can come with their child or children, boy as well as girl, or they can send their child and feel comfortable that they are in a safe space getting the care that they deserve. And so this bill now says that all health facilities, not just the Grenada Planned Parenthood Association, will be in a position to provide the kind of care and attention that our adolescents need. Allow me to share one other bit.
Yes, quickly, because I have to get back to Cassandra here and to Mrs. McQueen, because we have to, I think part of providing context as well is speaking about the genesis of this current legislation. In the intro we spoke about the deficiencies, but we had an entire spotlight initiative that Ms. McQueen worked on that I was familiar with. Many Grenadians were familiar with. There was an entire launch. There was a ceremony at the government of Grenada. Report was presented and all of that. But we want to get to that. So quickly make your point, and then I'll get back to Cassandra and Mrs. McQueen.
I'm happy to stop here because I believe this is the beginning of the conversation.
Yes, absolutely. It's the beginning of the conversation. And again, here on the Bubb Report, again, for full disclosure, these are conversations we have had. Cassandra knows this. I think Mrs. McQueen knows this as well. And sometimes when we have this conversation on this platform, the audience watching the conversation is a very, very small audience, right? And now you have this knee-jerk reaction. So some who might say, well, you're only having this conversation now because the bill has been presented. Absolutely not. These conversations has been had before, right? And continues to be have. Gender-based violence is something that, a lot of these women here have been talking about for years. So I think a lot of this reaction is a bit knee-jerk as well. But Cassandra, I want to get to you to do two things. One, quickly respond to what Dr. Frame just articulated here and Mrs. McQueen before her. And then we want to get to the final issue here that we're going to talk about, the genesis of this particular legislation in the context of the deficiencies that we spoke about earlier. Cassandra.
Thank you again, Dr. Bubb. I think there was a common thread that I'm hearing Mrs. McQueen and Dr. Frame mentioning, the need for more education, because there are parenting programs offered by the government of Grenada and CSOs, but the need for more parent education, around sex education, reproductive health. I think that's a common thread that I'm hearing, and that's something that I agree with. I remember speaking to one of our MPs yesterday at the Parliament building, and I was saying, while I know we as a grouping we are not necessarily disputing the data that is showing that there is an issue with sexual offenses and young people getting involved in sex. There should have been one discussions and dialogue with stakeholders. I heard Dr. Frim even mentioned the GPP as a stakeholder in the process for many years, was not even aware that this bill was in the back pocket of government. I think the knee-jerk reaction, while yes, we are seeing it, is warranted because there was not recent discussions around what the clauses that is instilled in this bill. That's why a lot of parents and other stakeholders are responding this way. So we do need more parenting information. I think I heard Dr. Frame mention that GPPA is actually going to the Parent Teachers Association. And it was something that I mentioned to the MP as well, because she said to me that one of the challenges that the state is having is that while these parenting programs exist, parents are not coming or they're not participating in the parenting programs. So I suggested, well, why not find an avenue or some strategy where you can go to them? The other thing that I put on the table is, and like Dr. Frame mentioned, GPPA and other CSOs and CBOs, NGOs tend to be the first point of contact. Why isn't there any discussions around empowering these organizations, maybe with more support from the state funding, to address these issues? Because they are the ones in the community. And we accept for years that government cannot do everything. But then there is an obvious disconnect between government and stakeholders in responding to what is obviously an issue in our communities and with our young people. One of the things I listened to Mrs. McQueen delve into some of the clauses in trying to explain not just my concerns, but the concerns of many parents read clauses in this bill. I wanted to ask the question about discrimination. I heard Mrs. McQueen mention about there are some young people who feel discriminated against. How does this legislation address discrimination, especially within the context of our Constitution? Because there is a definition in there. The other thing I want to put on the table, and I'm certain other parents may be asking themselves this question when listening to the presentation by Mrs. McQueen, why wasn't the authority given to an independent body such as Child Protection Authority or some other independent body to decide where these young people or parents fit the prerequisites that Mrs. McQueen mentioned?
As opposed to the minister fitting the prerequisite. Is that the distinction you're making here? Okay, very well. But I think again, and Cassandra, I cede to you on this because I don't care what anybody says. You are a constitutional guru, as far as I'm concerned. But when we speak of minister here, I think people sometimes tend to think that the minister has this sort of omnipotent, omnipresent power. Right? When I think the power of the minister, I mean, you can correct me if I'm wrong, is and the power of the minister in general terms now, not only in the context of this, but, you know, I've read many pieces of legislation and bills, and you had the minister shall do this and the minister shall do that, but it's within a certain context, no? Or within a certain limitation.
Oh yes, most legislations, when referring to the responsibility of a minister, does outline what that responsibility in the context of the legislation. But again, we live in small societies where there are partisan involvement that you cannot ignore. And I think that concern coming from the parents is a valid one. We have Child Protection Authority, we have other CSOs, NGOs who have been on the ground for numerous years, GPPA, for instance, who have done wonderful work working in sexual and reproductive health areas. Why wasn't there some insertion for an independent body instead of a minister as opposed to the minister? And the other questions I wanted to put on the table is, again, looking at the role of the minister and looking at the prerequisites in deciding which minor, 12 to 16, 17, benefits from that order as the legislation allows. You talk about young and single parents, uninformed parents, parents who are who fit the poverty prerequisites as outlined in a poverty assessment survey. Who decides those prerequisites? Again, the minister. And I am going to suggest a recommendation instead of just critiquing that maybe some discussions around an independent body be considered if there are any amendments that concerns
right, and you reference the Child Protection Authority there, that perhaps that can be the independent body without having to reinvent or invent, shall we say, a new independent body.
Yes, and then you have Section 41 and 42 of the Child Protection Act, which also speaks to the responsibility of care. So I hear Mrs. McQueen and Dr. Frame in regards to children not feeling comfortable and not in a safe space, but Child Protection has the authority. For instance, if a child has an issue and they have to intervene, and that's why I said there are mechanisms in place where children who are victims of sexual crimes, maybe a parent, a guardian, a close relative, friend, would have perpetuated some crime on them, there are mechanisms where the state now has a duty to respond to that individual. And if, because I've heard the conversations in the public space about so many parents being perpetrators of sexual crimes against their children, I keep saying the key word here is crime. And once a crime is reported, and as Mrs. McQueen knows, there's no mandatory reporting for certain sectors of workers. Once a crime is committed, then there are mechanisms for the state to intervene as a duty bearer to protect the right of that child. And again, I want to support, the call for more parenting, more information, but there are valid concerns with this bill. And again, I hear Mrs. McQueen in regards to the trying to explain the immunity cause. One of the challenges that we have had for a number of years is that we have very good legislations, and implementing those legislations is one of those issues. So we write them, they go to Parliament, they are approved, but how do we implement them? I think that has been a challenge. You did mention that there's been some training, but being in the space, and again, we mentioned the number, Dr. Frame used statistics and numbers. Do we really have enough trained personnel to respond to the number and the rates of sexual crimes against girls and our boys as we're seeing and reflected in our data? And again, are we really putting the cart before the horse? Why haven't we engaged? A member of the Bar Association publicly stated that she was not aware of this bill. I had the discussion to speak to another prominent attorney yesterday who said that he too was not aware of the bill. So you have our policymakers, again, arbitrarily making legislations on behalf of the people. And Mrs. McKean, I don't like the word leaders. They are representatives. So any decision,
I always say they are servants of the people.
Yes.
And
so
there was one politician. There was one politician who appeared on this platform, and he got very exercised when I called him a servant of the people. Very exercised when I said that. But I'm your boss man.
Yes, and I think that, and I think the outrage is reflect, and what's happened, that disconnect is reflected in the outrage what we're seeing in regards to
Ms. McQueen, Mrs. McQueen, I want you to respond to some of the recommendations, because Cassandra offered a critique, but in the context of that critique, there were recommendations. And the challenge I proffer here is in the context of those how can you see those recommendations perhaps being introduced as amendments to the amendment that we have on the table now? And then as part of that question as well, I'll ask you a second part. So respond to that first. Let's slowly,
sure.
Yes.
All right. Several recommendations were offered around expanding the parenting education program and making it, helping it to reach additional parents. A recommendation around having the Child Protection Authority or a similar body be responsible for the care and protection of those children who need sexual and reproductive health services, and so on. Recommendation about the need for good implementation, better implementation of the laws. I highlighted those because these are absolutely fantastic recommendations that I think should be considered going forward. Should they be included within the legislation, the proposed legislation? I do not see them fitting into the proposed legislation. I see, for example, the better implementation of law, as well as the additional or more effective parenting education coming in as a plan of action and a program that can be implemented in the furtherance of enforcing this legislation, among the other legislation to do with child protection and support for children to grow into effective adults, and so on. The one on Child Protection Authority or a similar independent entity.
And removing the power of the minister
and removing
here.
the powers from the minister.
Yeah.
Now, what does the proposed legislation say that it wants the minister to do? It says that it wants the minister to make regulation, that is the Minister for Legal Affairs, in consultation with the Minister for Health, to make regulation, if they see fit, for how adolescents who are 12 to 16 can be provided, well, 12 and under 16, how they can be provided with sexual and reproductive health care and services, right? Now, the Child Protection Authority or any similar independent agency cannot make regulation. But what the ministers may be asked to consider is if in the regulation they make, they can state that these are the roles that the Child Protection Authority or other independent entities should play. These are the roles that they would like to see these different entities play, and how they can work together to deliver the full range of sexual and reproductive health education and services to adolescents as they need. And that is to adolescents who are between the ages, who are at 12 but under 16. So I see that recommendation being considered by inviting the ministers, following the passage of this bill, asking the ministers to consider putting the role of the different service providers, including Child Protection Authority, within the context of the bill.
Viewers and listeners, this is the Bubb Report. We'll be back for the final segment of our conversation on dissecting the Age of Civil Responsibility Amendment Act 2025. Do stay with us.
Should your loved ones pass on, they deserve to be treated with dignity. And at S.A. Johnson Funeral Home, we can provide you with that service. We can take you every step of the way during your sorrowful moments. When that need arises, call S.A. Johnson Funeral Home at 347-777-9797. That's 347-777-9797. S.A. Johnson Funeral Home is a Caribbean family-owned funeral home here in Brooklyn, providing funeral services, but in a dignified way. From cremation to burial to the repatriation of your loved ones, you don't have to go through the hassle, as we provide exceptional service that allows you to mourn and heal peacefully. For more information, visit our website, www.sajohnsonfuneral.org. Send us an email at sajfuneral@aol.com or call 347-777-9797. S.A. Johnson Funeral Home, because you deserve to be treated with dignity.
This is an issue that I have here. On the whole question, and I do want to go ahead, I have several PDFs open, but I really have to share the report of the Spotlight Initiative. Let me all over the place here. It's okay. So again, in the context of the genesis of the legislation, and I want to reference, I believe it's Annex, let me see what it is, Annex D of the Spotlight Initiative's annual narrative program report. And this has to do with this whole question of consultation, Cassandra. And this is not a critique of you, because I know you are in the vineyards where that is concerned. I know that Dr. Frame is in the vineyard working with parent groups and working with various stakeholders. But sometimes, Cassandra, I just think, when stakeholders invite the national community to public consultations, 10 people show up, 5 people at best, right? They see it as a wonky thing, quite frankly, as a boring thing. But when something like this happens, let us go back to the 2016 referendum debate, Cassandra. When the referendum got heated? After someone who is currently in government wrote a particular article on the gender question. Then the Trade Center was filled to the brim. But there were consultations that your caucus had around that time that seldom anyone, George Grant, the late George Grant of blessed memory had several programs on his platform where you were involved in, right? And no buy-in from the community. So the reason why I'm bringing all of this up is to say, yes, there is this red herring of, well, there was no consultation. But when you ask the citizenry to participate in consultations, they're not there. What say you? Cassandra?
I agree with you. That's why I'm nodding. And having been part of the Spotlight Initiative, I've shared publicly that, yes, there were 1 or 2 consultations, and yes, they were poorly attended. I remember meeting with a consultant in the person of Attorney General Darshan Ramdani, and there are only 2-3 people in the space. And I have to say to the consultant, this is a much needed discussion, but 3 of us in the space do not represent the diversity of civil society, which is trade unions, faith-based organizations like GPPA, Girl Guides, others. And these consultations were very poorly attended. I think the last one we had may have been sometime in April, June 2022 or thereabout. And again, 3-4 people in the space. So I agree with you. And again, going back to education and getting people interested in what's happening within our governance structure. We should not only be showing up only when there is a political rally. And I've said it all the time. We seem to not be able to
politicizing legislation, quite frankly, as well. You know what I mean? But Ms. McQueen, the reason why I'm bringing the Spotlight Initiative report, because I actually read the report, right? In the report, I believe that's Annex D now, it references this. And of course, Annex D, just for the benefit, or Section B, I'm saying Annex D, it talks about the knowledge products here, but it talks about the knowledge product, the brief description of the product, and the dates to be completed, right? But in the context of this annex here, it speaks to, and I'm quoting from it, a position paper needed on reform to eradicate all forms of violence against women and girls. And then it goes on to talk about the need for an age of autonomous consent of adolescents to sexual and reproductive health, the need to reintegrate pregnant adolescent mothers into formal education institutions. But the point about this child maintenance, the point about this is that, and the reason why I'm bringing this up is because this was referenced before. A lot of work was done on this before, right, Ms. McQueen?
Yeah, under the project, the consultations in relation to this particular subject matter took place in 2 different sets of processes. One set of processes had to do with Pillar 1. That is to do with the pillar called Law and Policy Reform. So consultants, including Mr. Darshan Ramdani, who became a consultant right after having been the Attorney General of Grenada, he picked up from a previous consultant and did some work to complete a mapping of the gaps, a gap analysis in the law reform as it relates to gender-based violence and protection of women and girls. Came up with several recommendations, including this one. and then continued to develop position papers and draft legislation which were discussed. In a similar at the around a similar time, there was another pillar that was also looking at adolescent health, and that pillar was Pillar 4, that had to do with services, the provision of services. And Dr. Frame, among some other consultants, were involved in those processes, talking about adolescent health. And they were consultants as well, talking about reproductive, sexual and reproductive health for adolescents, and how can those become more available, more affordable, non-judgmental, and so on, setting up what should be the principles by which adolescent health services should be provided. Now, those two sets of activities led to a number of things, including policy proposed as well as laws proposed. So the adolescent health policy, for example, was drafted and proposed. Victims' rights, so policy on the rights of victims and survivors of gender-based violence was developed and proposed. These model draft bits of legislation were also developed and proposed. Now, consultations specifically to do with the law reform included consultations with specific groups and broader number of groups. The specific, now remember too that some of it occurred during the period of COVID. So a lot of it was online, I must say, right? There was data collected, there were group discussions, there were interviews, there were some online focus groups and discussions, and best practices and sample legislation from other countries were also considered. The position papers and draft bills were circulated for feedback, including from the Bar Association, the Grenada Bar Association, and some lawyers actually did respond and offer suggestions, not necessarily on every piece of legislation. Coming out of that, there were about 17 bits of legislation. And we actually do hope that the government will continue to consider those legislation going forward, the other ones which are not yet tabled as well. In 2022, the Grenada National Organization of Women organized with UNICEF a national consultation, and that was face-to-face, but it was also brought online as a hybrid for persons who were not able to be in the room. And in 2023, it was a latter part, I believe, of 2023, there was a session with an all-day session with parliamentarians. All parliamentarians were invited, and many of the parliamentarians participated and discussed it as well. The bills were with them. The bills were with also the reports that went with it also went to civil society through a process that was developed for the Spotlight Initiative called the Civil Society National Reference Group, which Cassandra, you may recall, being on that reference group as well. And different ministries of government were also involved through the gender focal points, through the technical personnel, and so on. So this, in a nutshell, sort of summarizes, I hope, the range of the consultations that took place. Entities such as the Program for Adolescent Mothers, and so were also involved in different things. And so during the GNO consultation, I recall they brought in students from TAMCC were among the attendees in the room, together with lawyers and other civil society entities and so on. So this is the range of the consultations. They started mainly around 2021, but went up to the end of the Spotlight, which was in 2020, the end of 2023. Yeah. So
Yes.
We know that there were very heavy consultations as well. I say heavy because we were talking about different themes, and as you had just put up on screen, there were a range of things that were being discussed. As it relates to child protection alone, those items you mentioned, Dr. Bubb, were all there. But then there were other aspects as well, such as sexual harassment, such as how do we further strengthen the Domestic Violence Act, and several other aspects of the legal and policy framework. Yeah. So this gives a sense as to what happened then. Some persons may have been invited and not shown up. Some persons may have come. Some persons came as representatives of an entity. And it is not a surprise, but just a note that sometimes when a person represents an organization or a ministry of government, the information stays with the representative. So although the professional body or the ministry or the organization was represented, only the person who is the representative is aware. So other persons who belong to that professional organization or civil society or ministry perhaps had not received information from their representative or sought advice sought from them as well. So we also know that that is a flaw in a lot of the consultative processes, and it might have affected this also.
Absolutely. Ladies, I think we have really exhausted this time. We have gone over 2 hours. But again, this has been a very incisive, very deep diving conversation. So Dr. Framer, I do want to go over to you for some closing comments, because we promise you here on the Bubb Report that in advance of the passage of the legislation, or when it's brought up for second reading and perhaps third reading again, let's see what amendments will be included based on the conversation we had today, I suppose, based on the public feedback that we have been seeing. But certainly there will be a part 2 conversation in September on this conversation. So Dr. Frame, I'm going to go over to you now for some closing comments.
Thank you, Dr. Bubb, for the invitation and
yes,
the opportunity to engage these 2 ladies who, they're in the trenches as well,
yes,
and know this topic well. However, I encourage you not to wait until September. I think let's have ongoing conversations on this as much as your platform will allow. I know you're a busy and popular program, but from the Grenada Planned Parenthood Association, and we would like to continue the engagement. As I said, we're very happy about the public discourse, and we welcome all viewpoints. So it's not just about hearing those who support, but we want to understand where people have differences of opinion on this bill. So I was very happy to hear Cassandra Mitchell's recommendations as well. And so we want to hear from the public, because our intention going forward is to engage the population in having more conversations to better understand the issues, to get some more recommendations, which would also inform our recommendations when it gets to that point. But as a public health professional and someone with a lot of experience in sexual and reproductive health and rights, I want to encourage the population to think of this as the seatbelt law, right? Preventive. Yeah. Before we had the seatbelt law, we didn't know that we need it. Most of us never even thought about it, and we were quite happy driving without the seatbelts. Now it's second nature to us. It's not a big deal, right? And it saves lives. That is what law and policy does. We're not stopping at law and policy, but we're going to continue to engage the population. We're going to work towards putting the mechanisms in place to ensure enforcement. And if there's nothing else you can rely on, I'm giving you my assurance from where I sit currently as the president of the Grenada Planned Parenthood Association, that we are about community, we are about family, right? And this is, I'm going to say it, this law is not about free sex. This is what people hear when they hear anything sexual and reproductive health and rights. This is not what this is. This is a seatbelt. It's preventive, right? And so you have our assurance that we are here to serve the community in a way that promotes and protects the well-being of our young people. It is our top priority. We have a movement called the Youth Advocacy Movement of over 150 young people dedicated. They give their time freely to provide information and education across our society to young people, but to anyone who would listen. And we will continue to engage. So when we approach you on the streets or in various places, be open, have a conversation with us, and share your comments, share your concerns, share your support, whatever it is that you have. We are there to listen. That is all I want to say at this time.
Absolutely. Cassandra, over to you for some closing comments.
Thank you, Dr. Bubb. Thank you, Dr. Frame. I want to take the opportunity to call on our policymakers to engage with the people, listen to the concerns of parents. The concerns are valid. Keep your word, honor your word that there will be future consultations. And once the recommendations coming out of these consultations are valid and can lead to the amendment or further amendment of this principal act, I would like and call on you to take that into consideration. I would also like to now publicly state that we as civil society have committed to assisting our government on the basis and the principles of respect for the rule of law, respect for our constitution, respect for civic engagement. And as long as that happens, we are here to support you. When that fails, we are going to hold you accountable. Parents or children are out there having sex. The data is showing that they are vulnerable and at risk. Now is the time the government has placed on the table the opportunity to have some consultations, some conversations with our representatives. Come out and let your voices be heard. If you fail to do so, the law is going to exist in its current construct. We need to protect our children, generations of Grenadians. We need to do so, and the time to do so is now. Thank you, Dr. Bubb, for this opportunity.
Thank you so much, Cassandra. Thank you for the work that you do in that civil society space. Ms. McQueen, over to you. You're a bit frozen. The internet is coming in and out, but we can still hear you. Over to you for some closing comments.
Okay. Thank you so much, Dr. Bubb, for having me on this discussion. And as you say, continuing the trend of having discussions on issues that sometimes we're afraid to touch. So thank you for that. I want to close by saying to us that silence, fear, stigma around sexuality, sexual and reproductive health and rights will not be the answer. They have never been the answer in all of our past. It cannot be expected to continue. And in fact, silence and fear only help abusers and disempower those who need support. And so this proposed bill is seeking to open the conversations and open the space for having these kinds of conversations in professional settings where people can have questions answered, services rendered, advice given, without having to deal with stigma and judgment and fear. And those persons who are the most vulnerable are the ones who will benefit most from these proposed legislation. Again, I say fear does not protect. Silence, in fact, protects the abuser, not the vulnerable. Let us provide the options so that those most vulnerable have spaces, have access to information, to service, to guidance and support so that they can be empowered to make informed decisions about their own personal health, that is sexual and reproductive health. A person generally tends to make the best decisions when they have available to them and they receive the best information and options, and then they make the best choices for their lives. Persons who do not have access to information, or that information might be available somewhere but not made accessible to them, they then act on what they hear, by the way, what they learn on the blocks, what they see on the internet, what they hear in the songs during Carnival. They do not have balanced information with which to make decisions. Let us, I encourage us, let us give support to this bill so that the government will recognize that the people will be willing to advance our society in a way that allows these kinds of conversations and empowerments to take place, and that when the bill becomes law, that all the systems for support of the implementation of the bill will also be made available. So I encourage us to continue the frank discussions, keep bringing suggestions to light, and where those suggestions can be included, for example, within the regulations that the ministers may need to make later on, that those will be taken into account. But let us all recognize that our adolescent girls and boys do need us, and they need the options, they need the space, they need the information. Let us allow that to happen in safe and professional settings. So thank you all for listening, and thank you, Dr. Bubb, for the opportunity.
Absolutely. Viewers and listeners, this was really a deep dive conversation on the current age of civil responsibility legislation that is before the national community. Of course, it was only tabled for first reading. I'm not too sure if the intention of the government was to move this bill through all of its stages in the last parliament sitting, and whether or not they decided to just table it for first reading following the public backlash that ensued as a result. What we did witness after the public backlash was a press release from the government. What we did witness also on various social media pages of government ministers was an explanation of what was contained in the bill and the implications of the various subsections of the amendment. Now, that was not done before, and had it not been the eagle-eyed journalist Linda Strake and others who actually published the story on this, then perhaps the national community might not have known about this before Parliament met, right? So I think it's important for us as citizens to really mind our business, and, see what is on the order paper, see what is coming up for legislation in Parliament, so that you're not caught surprised or flat-footed when legislation is passed before Parliament. And of course, the government as well has a responsibility to let people know that, hey, these are the pieces of legislation that will be coming to the fore. So again, I do apologize because we were not able to take any comments live on air, as this program for this week, in fact, was recorded before this Sunday, as you know, I'm actually traveling and was unable to do the program live. So on behalf of the producers of the Bubb Report, I'm your humble host, Dr. Kellan Bubb, We thank you for watching this week's edition of the Bubb Report. We'll see you next week, Sunday, for yet another installment of the program. Take care. Bye-bye.